Hello and welcome to the Housing Subcommittee meeting of the California Paraprofessional Program Working Group. Take roll. Falmouth.
Here.
Judge Harper.
Here.
Hartston.
Here.
Sarouche. Don't see her. Oh, okay. Sarouche, I'm just taking roll. I think Fariba just joined us.
Hi, I'm here.
And Spyro. Ira? Oh, Ira stepped away. Oh,
Sure.
yes.
I'm back now.
Okay, great. Thank you.
It's my second meeting in a row.
Yes, okay.
I'm here.
Thank you. Okay, we're all here.
Should we see if there's any public comment?
Sure. If there is any member of the public that wants to speak, please use the raise your hand using that Zoom function. Judge Harper, did you want to set a time limit for speakers?
Yeah, well, we do 3 minutes and to start.
Okay. Richard Walker.
Hi, thank you for the opportunity to speak. My name is Richard Walker. I'm a senior staff attorney at the Public Law Center, a nonprofit organization in Orange County that provides free legal services to low-income residents and families. I specifically work in the Housing and Homelessness Prevention Unit and have experience in housing issues, including eviction defense, title issues, impact housing cases, affordable housing, etc. I want to suggest today that as the working group is looking into these issues, that you take into consideration a few things when determining whether or not a subject is appropriate for paraprofessionals. So one, I think it's important to take into consideration the high stakes that are at play in the case and the potential consequences to the individuals seeking services. Also take into consideration the complexity of the issues and the actual unmet need that might currently exist. For example, as to high stakes, we're concerned with paraprofessionals working on home ownership and title issues because of the risk of losing a home and because of those high stakes that are involved in such title issues. And we also question whether or not there's actually an unmet need in these areas that would justify the need for paraprofessionals to be working in this area. Another area of high stakes would be cases that involve subsidized tenants, where the tenant's at risk of losing a subsidy or a housing voucher or some other form of rent-controlled unit, because that's going to have negative consequences that are very lasting and detrimental to the client if they don't receive the best services that they should be receiving. And so because that's another area of really high risk and also contains additional complexity with federal regulations and other regulations beyond just your regular landlord-tenant law that come into play in those cases, as well as in rent control cases that also include local ordinances, in addition to the state law, that make those issues a little bit more complex and present a high risk for the tenants. And so we suggest that you take into consideration those high stakes and complexity, issues like security deposits, where we're talking about lower amounts of monies. There's not a risk of losing a lifetime subsidy or losing a home, might be a more appropriate area for
30 seconds remaining.
And with that, those are all my comments. Thank you.
Thank you, Ms. Walker.
And we have another speaker, Carol McBurney.
Hi, my name is Carol McBurney. I work at Legal Aid Society of San Diego on the Schreiber Housing team, where I'm the senior attorney in that team. I would ask this committee to reconsider the use of paraprofessionals for unlawful detainer cases. Specifically, the concern is that even a paraprofessional who receives initial training about how to litigate unlawful detainer cases are going to be faced with new challenges every time the law changes. And I think as we've seen over the last year in the unlawful detainer world, there's just been an influx of new laws that have affected how these cases are litigated. And if a paraprofessional receives their training they're not going to be likely receiving such ongoing training that every single time a new law comes out, the paraprofessional is going to get training on how to interpret and implement that law. And the concern is, additionally, if a paraprofessional is interpreting a law and arguing it one way, and opposing counsel on the other side is actually an attorney, the concern is that a judge would give deference to the attorney rather than the paraprofessional in light of their law school degree, which can be really detrimental to clients. Additionally, there was discussion at the last meeting about having paraprofessionals work on security deposit issues. I thought that was a fabulous idea. Security deposits often get litigated in small claims court, where of course tenants are not able to have any attorney represent them. And to have a paraprofessional work with a tenant to try to recover a security deposit, I thought was a fabulous idea, and was an area of law that is a lot more straightforward and less ever changing, I guess you could say. So I did think that is an area of need, and an area that paraprofessionals really would be able to assist in and fill in a gap without unduly harming the right to counsel movement as well. Because of course, even though I don't think that is at all the intent of this subcommittee, I do think that having paraprofessionals move into the unlawful detainer sphere, litigating cases, including things like
30 seconds remaining.
and trials, would definitely affect the the right to counsel movement in a very negative way. Thank you so much for taking these issues into consideration.
Thank you. I don't see any other public speakers.
Okay. Great. Thank you, Linda. So I think Linda sent out an agenda today, and I think first we're going to have a speaker, Barbara Schultz, going to talk to us about the LA Right to Counsel Coalition. But I think one thing we wanted to tackle today was to try to get an agreement or a consensus among the committee members whether we should actually include unlawful detainer. And if so, then we can start moving forward. But if not, then where do we go? And also the title clearing issue. So I think those are the first things we need to tackle. But I think hearing from Barbara Schultz first, I think would be helpful. So I think, is Barbara?
I'm here.
Okay, great.
And Amos invited Barbara to join us. So maybe if you want to do a brief introduction.
Happy to. So we are very lucky to have a true housing expert with us today. Barbara Schultz at the Legal Aid Foundation of Los Angeles has been working in housing law and public interest legal services for many, many years. I think I actually don't know Barbara's current title because she's gotten so many promotions since the last time we worked together. But Legal Aid Foundation of Los Angeles, it has been involved in the Shriver project. But even before that, Shriver doing full representation in unlawful detainer cases. But even long before that, Legal Aid has really been a leader in the housing area. And so I turn it over to you, Barbara, for any further background.
All right, thank you very much. My name is Barbara Schultz. New title, actually, Director of Housing Justice at the Legal Aid Foundation of Los Angeles. And LAFLA is involved in the Right to Counsel Coalition and also Stay Housed LA, which I'm going to talk a little bit more about. I'm going to share my screen and see if I can figure out how to open and start this. All right, so the Right to Counsel Coalition started about 3 years ago in LA. We have 67 organizations that are involved in the effort. So it is quite sizable. These are legal services organizations, community-based organizations, primarily tenant organizing groups, academics, but our list of endorsers goes far beyond that, including unions, service providers, and other organizations. So,
Barbara, I think we have your presentation screen.
Oh, sorry, that's probably my fault, and good question on how I stop that. This is like a new nope. I've not used this version of PowerPoint before. There we go. Can you see my main slide?
Yeah, we see your whole screen, so it includes the.
Okay, yeah,
Buttons.
sorry.
I think there's a way you can disable presenter mode. We're
Okay.
having this in a lot of our Zoom meetings.
I'm gonna stop and then try again. How's that?
If you just go into the little search box and
Yep.
type presenter, you can uncheck presenter mode.
When I'm in the PowerPoint?
When you're in the PowerPoint, see where it says display settings?
Display settings, yep.
I think you can
Yeah, I looked at that.
swap presenter view and slideshow. There
There you go. Thank you. Gosh, I've learned something already. So right to counsel really is our answer to the justice gap in the UD context. The purpose of right to counsel is to ensure that people under a certain, well, really to ensure that all tenants have the right to get an attorney to represent them. What we ask for is that it publicly funded for those under 80% AMI. And then we are partnering with law firms that are sliding scale law firms, for instance, that can assist those over 80% who need a sliding scale. And our version of right to counsel has kind of three elements. There's the actual eviction defense, of course, but there's also eviction prevention, education, and outreach. And so a lot of the tasks you may have been thinking about for paraprofessionals really are covered in our right to counsel model. And then also short-term rental assistance. And just a little factoid here, New York City, the first to bring on right to counsel, they have found that 86% of their represented tenants have kept their housing, 97% of those in subsidized housing, and there was a 30% decline in eviction filings as an effect of right to counsel. So right now we are implementing the right to counsel as a program funded by the County of Los Angeles, and it's called Stay Housed LA. And I encourage you all to go to stayhousedla.org. This is a website where any tenant can go to. They can find know your rights information. And this is also where they can seek legal assistance. You just click a button that says get legal help. You answer a series of questions. And then if you are eligible, you will be automatically assigned to a legal service provider. You can also get connected with a tenant organizer group. You can also decide to attend a workshop just to get a little more information about know your rights. So again, there's the public awareness, the outreach and education, and the legal services. Because of the protections that are in place right now, we have been doing a lot more limited legal services, basically because there haven't been quite as many evictions. So we've been doing a lot of counseling and advising about the COVID protections, about declarations, about harassment issues, but then also providing full rep for those who are in eviction. So just to give you a sense of the breadth of it, so far we have a contract with the County of Los Angeles that started in September of 2020. And I should say that predating the pandemic, we were actually going to start a different program that was going to be based on zip codes. It was going to be a full right to counsel in particular zip codes. And then our plan was to just expand that. Once the pandemic hit, political thinking changed. So we are now in all 11 courthouses in LA County, but as of now, we haven't had an issue with capacity, but certainly once the what is expected to be a huge increase in UDs, there will definitely be capacity issues to handle the entire county. What we're looking at is a phase-in process for a full right to counsel. So currently we have contracts with the County of Los Angeles, and we've just started one with the City of Long Beach. By the end of the month, we'll have another contract with the City of Los Angeles, the City of Santa Monica, and one of the Los Angeles City Council districts, a pilot right to counsel program there. So it's roughly between County of LA, City of Los Angeles, it's probably about 14 million. And the City of Long Beach and City of Santa Monica have smaller programs. And so with these programs, this is what we provide. A public awareness campaign. This is, digital ads. This is going to start appearing on your social media. You're going to start getting stay housed if you go to the website. Outreach. We've outreached to over 200,000 tenants by phone and text. Just to tell them what their rights are and to let them know that if they need an attorney, they can get one. We've had over 250 workshops where we do know your rights, and then often we have a clinic afterwards for one-on-one consultations with legal service providers. And then for legal services, as I said, we've done a lot of limited scope. Over 8,000 tenants have been advised with limited scope cases, and we have over 700 full scope eviction cases. And again, since September 15th, I believe was our start date, though it took folks a little bit to hire. So our primary concern about a paraprofessional program is that it undermines right to counsel efforts. Again, we see this as the answer to the justice gap. So, we have managed to get all of the providers together, both tenant organizers and legal services, which is not a small task. We now have a one-stop shop. You go to Stay Housed LA or you call our toll-free number and you will get connected to one of the legal service providers. So one thing I would suggest is that if this is moving forward in the UD context, that jurisdictions that are moving towards a right to counsel should be exempted from the program. We just have generally had extremely bad experience with notarios. We often, I think one of my colleagues came in a couple of weeks ago and told you about a client that he represented. He had to fix all the problems that the service had created. Sometimes it's too late to fix problems. Recently, we did an answer for a tenant. We offered her full scope representation. She declined. A few weeks later, she called back when she had the sheriff's notice to vacate on her door. She said she had chosen to go with a notario service of some kind. As a result, she was evicted from her home. Because she didn't understand that it would have been far better to go with the Stay Housed program and have an attorney to represent her. This is a particularly problematic in immigrant communities and communities of color. I'm sure you've heard many of the stories about notario fraud, specifically within the immigration context. So having this program anywhere, I really think is going to require enforcement, oversight, and public education about what paraprofessionals can and cannot do. Assuming that this paraprofessional program does move forward, the first thing I would say, of course, is that if funding could be found to give legal service providers more funding to hire paralegals. I mean, paralegals are incredibly useful and incredibly, we absolutely need them in our program, but we have attorney oversight, and paralegals do everything up to going to trial, but they need to have attorney oversight. like many of the public folks I'm sure you've heard from and that we heard from today, small claims certainly is an area that I think that paraprofessionals could play a role in. Obviously, you've heard about security deposits. A lot of times people are trying to get their personal property back after they move out, or damages for those personal properties. There are some local laws where there's statutory damages, but the cases are too small to bring an affirmative litigation. Perhaps, they could be assisted with trying to bring some of those cases for, relatively small amounts of statutory damages. In the UD or prevention context, perhaps in non-right to counsel jurisdictions, there is a place to draft answers and explain the UD process. But I would really want to see a requirement that they were referred to legal services for representation. Just doing an answer without the fee waiver, if applicable, or without the proof of service is kind of useless, honestly. So it'd be really, that would have to be included. I don't think that paraprofessionals should play a role in court representation. And because this is a measure to look at the justice gap, I think there has to be a fee cap. And I'm sure you've heard this before, but one suggestion is that you look at the DOJ Executive Office on Immigration Review. They're the ones who regulate their non-attorney immigration reps, and they have to have fee schedules. So I think that is something you could look towards. And that is all I have for my presentation. So if anyone has any questions, I'd be happy to answer them.
Looks like Ira has a question.
Yeah, I probably, I have a couple. Well, anyway, I participate in these public sessions that are part of Stay Housed LA 2 or 3 times a week, and I don't take litigation. I do advising and negotiating. And I've seen that, well, no, let me big my question a little more. Yeah, the first question is, when you said, Barbara, that if we have paraprofessionals working in housing or unlawful detainer, it should be only where there are not right to counsel something. How would you phrase it?
I would say jurisdictions that are moving towards a right to counsel, because it is a process. Like in New York, their process was to phase it in over 5 years. I think they're in like year 3. It's not something that we're going to do immediately, but we are absolutely going to get there within a few years. But I think, I really do believe that a program like this could completely undermine the political will to get to the full right to counsel.
I understand. I'm thinking of phrasing something exactly what you're talking about, but I don't know how to define the limit. Are you talking about, in other words, how to define the jurisdictions where there shouldn't be such a program for paraprofessionals? Would it be where there's a contract, where there's something else? How would we define it?
Well, certainly, obviously San Francisco is easy because they have a codified right to counsel now. In LA, we are moving towards a codified right to counsel and hope to get there. So I would say either a codified right to counsel or, a funded program that is moving towards a full right to counsel.
Excuse me while I jump in, and excuse my ignorance, but do we have a list of what that would encompass at this point? Which cities or counties would fall underneath that rubric?
At the moment, I know of obviously San Francisco, obviously Los Angeles. I understand Fresno is also working towards something. I don't know how far they've gotten. But, we are also working on AB 1487, which hopefully will provide funding for more jurisdictions to consider a right to counsel.
I have a further question. Barbara, am I right that your position, LAFLA's position, right to counsel's position would be that even in jurisdictions where there are contracts or codified right to counsel, that paraprofessionals working on security deposit cases would be okay? That's one. Do you think so or no?
I certainly think that would be less dangerous than working on UD issues,
Well, yeah.
or family law issues, quite honestly, and potentially the expungements too. So I think that certainly could be one area.
And also for those who don't know, Los Angeles passed an ordinance providing for a statutory cause of action with a $10,000 to up to $10,000 penalty. And I think that's an example of what you were alluding to before, Barbara, about the statutory damages. So do you think that paraprofessionals would be okay in jurisdictions that have those small statutory causes of action, even where there is right to counsel contract, say? Or
yeah, I mean, I think that there are various state and local laws that allow for statutory damages for several different things. If a landlord harasses you, you might be eligible for some statutory damages. If they, terminate your utilities, if they do a variety of things, it is possible. You could actually, we often tell clients that it's probably safer when they have habitability issues, rather than risking eviction and withholding rent. It might be safer to try going to small claims court and seeing if you could get some damages there. So I think those are some other ideas. And obviously there are small claim court advisors, but it needs a little walking through. And there are a few programs around the state to try to deal with the consumer debt issue, but and LAFLA actually has one of them, but very small. I don't think it's going to be able to handle all of in anywhere near all of the need.
And I think this is my last one. A lot of people in Los Angeles County, anyway, when they go to stay housed LA, they can't get a lawyer unless they've been served with a complaint, unlawful detainer.
Mm-hmm.
And that's where the work that I do and lots of others in advising them and negotiating for them. So even in a jurisdiction that has a strong right to counsel contract or an ordinance even, do you think there's still a place for paraprofessionals to do negotiating and advising? I mean, these are not always small negotiations, folks. These can get up into the mid 5 figures for buying out a tenant who's there under rent control, for instance. Well, anyway, what do you think?
Well, I just want to correct something you said. We have advised over, I think it was 8,300 tenant households on issues up to the actual UD. So we are doing a lot of limited legal services for folks for exactly those things. And what we say to them is, when you get the UD, just call, here's my number, call me back and we will represent you. Our actual program is supposed to begin at the notice stage, but because of all the COVID protections, we decided not to do that now, just because someone may well get a notice to pay, rent, or quit. But once we assist them with doing the declaration, it goes away. So if the landlord is following the law, of course. Some of these things are very specific to the time that we're living through. And I think one of the public speakers mentioned this, and it's so true that UD law has become incredibly complex suddenly. I mean, the number, we have, 89 jurisdictions in Los Angeles County, and it seems like each of them has a different COVID protection. So it is very complicated right now. So it's important that people even get the correct counsel and advice from folks. And I think that the tenant organizers also play a really important role in terms of the education they're providing and the workshops they're providing. And then they're the connection when they get to a point where they're going, oh, this is now a legal issue. I'm going to turn you over to this attorney, or this person at the legal services to assist you.
This program for paraprofessionals probably isn't going to start until for another year and a half at least, probably later. And I think we all think that the COVID-19 pandemic will be over by the time this program starts. So do you agree that the big, and it's quite complicated now about way more than it used to be, but it's entirely because of the COVID-19 laws, don't you think? Well, there's one that isn't, the Tenant Protection Act.
Yeah, not in LA, because there's so many different rent stabilization ordinances as well. It is kind of complicated trying to figure out which law actually, is in play in a given case.
What I mean is when those COVID-19 laws are gone, hopefully they will be in 2 years,
Right.
Lawful detainer won't be nearly so complicated, don't you think? Or maybe
except for the rent stabilization ordinances. Again, just because in LA County, just because we have so many different jurisdictions.
Yeah, that's right. I'm sorry, I missed what you said.
That's all right.
That's true, the rent stabilization. Okay, I'm done.
Okay, Amos had a question, then Fariba.
Thank you, Barbara, for that presentation. Very helpful information. I just had a question about the income guidelines for the LA right to counsel or the current stay housed LA, either currently, but also what you're proposing for going forward. And also you mentioned sliding scale firms when somebody, for whatever reason, they either don't qualify or capacity limitations, they're not getting a free attorney through legal services. Can you talk about what that looks like, how much it costs, and capacity of those firms?
Sure. In terms of the area median income levels, the County of Los Angeles contract right now only goes up to 50% AMI. Our original plan was to go up to 80% when we were going to be in just a few zip codes. So we're hoping to get back up to 80. The City of LA contract, which is about equal size to the county contract, and should be done by the end of this month, will go up to 80% AMI. All of our proposals around right to counsel go up to 80% AMI. In terms of the sliding scale law firms, I mean, to me, this would be another great thing to think about in terms of the justice gap. And that is figuring out how to grow the capacity of other firms to do sliding scale. Right now, we have the two kind of best known firms that do this in LA County, which is Eviction Defense Network and BASTA. Both are involved in stay housed as well, but they're kind of doing the free services under the contract and then their regular business model. We have a variety of solo practitioners that do UD defense that I'm sure also probably have a sliding scale, but I actually do not know much about what that sliding scale is.
Fariba.
All right. Hi, everyone, and thank you, Barbara, for all the great information. So I have some questions. I want to start with whether you have any stats for your county in regards to the percentage of SRLs on UD calendars?
SRL, sorry.
A percentage of SRL tenants on your UD calendars in LA?
What's SRL?
Self-represented litigants, my
Oh,
apologies.
I'm sorry. I mean, well, no, I can't even.
But let me tell you why I'm asking is that you have in LA, you're talking about the right to counsel. And I'm just wondering, in theory, sounds fabulous. I'm just looking to see what the impact is in practice. So if you have up to 90% of tenants represented, low-income tenants represented, then great, it's working wonderfully.
Right.
Well,
Well,
you have that information?
as of 2018, I think 2018 or 2019, there were about 40,000 UDs filed in the county of Los Angeles. So we are building our proposed right to counsel in order to be able to represent in 30,000 cases, figuring that 25%, there'll be obviously we hope to lower the default rate, but to be honest, the default rate is probably 50% at this point. So through our education campaign, we want to lower the default rate, but there will always be people who default. Plus there'll be people that, either just decide to move, folks that might not be eligible for the free services. So that's our plan, is to try to hit 30,000 UDs. If you look at New York City, they have, oh boy, I just talked to them, over 100,000 UDs. I mean, they're just a huge number, and they are halfway to their right to counsel. They have 500 attorneys right now in their right to counsel program. They're eventually going to get to 1,000. So this is doable. There just has to be, the political will and public funding to do it. And we absolutely plan on making that happen in LA.
Okay. So I'm just wondering, as Iris said, I think we're expecting this program to be launched in a year and a half. And I'm just wondering if when you and others suggest that this program doesn't take off in jurisdictions that have a right to counsel program, I'm just thinking about options. There are people who can't afford it, fine, they will go to free alternatives, but there are people who may be wanting some private assistance. I'm just wondering, why eliminate the choice for everybody in hopes that the right to counsel programs take off and they actually are effective? And that's my hope too. It's just, I'm just wondering, why eliminate the choice for everyone?
Well, I think that with some of the sliding scale firms, folks could potentially afford an attorney, possibly even more than a paraprofessional if there's going to be no fee caps involved, right? I mean, I think the real concern is just the damage we have seen caused by notarios, paraprofessionals, unregulated. It's terrible.
Right. Oh, absolutely. I mean, I'm the director at Self-Help Center here in Santa Clara County, and I see that firsthand in UD and family law. And I'm just thinking the positive impact that a program that licenses and regulates these folks, these professionals, hopefully the impact it will have on eliminating the bad actors, and then have that kind of option coexist with the right to counsel and Legal Aid Foundation and all these others would be a great thing for the public, rather than limiting their choices. I'm just putting that out there. You don't have to answer anything. The other question I had for you was, I have two more questions. One is outreach. How do you, I mean, I heard you say that tenant organizing groups have an impact on letting people know to get in touch with agencies like yours. And then you talked about you were supposed to get involved at the notice stage, but because of COVID-19, this is not happening. But I'm just interested in knowing, how do people find out about you?
Yeah. So first of all, we absolutely do get involved in the notice stage. It's just we might not offer full rep at that point.
Oh, okay.
But sure, there are Liberty Hill Foundation, a small foundation in Los Angeles, has the contract with the county within the Stay Housed program to run that side of things. So they hired media consultants. They run digital ads. they're doing all sorts of things digitally right now, of course. We have hopes that it can become non-digital soon, but literally they got voter rolls, and we were targeting specific low-income communities that the county had requested that we target with targeted outreach. So those were the phone calls, the texts. We have done a lot, all of these work groups, workshops that we've done. We've done workshops in combination with the Board of Supervisors. The first one we did had 600 attendees. The government agencies are certainly telling people to go to us. Our county contract is with the DCBA. They have like 50 operators that are, answer the phone to talk to people, and they will put people into the Stay Housed program as well. The city of LA will be starting to do that soon. So basically everyone is just pointed towards either the Stay Housed website if they can cross that digital divide, or our toll-free number for those who can't. We recently brought into Stay Housed Asian Americans Advancing Justice, so that they can run, get all of the folks who are monolingual in 6 different Asian languages. We obviously have the capacity for English and Spanish, as well as some other languages between all of us. We use Language Line for anyone who has who needs it. So we're really trying to outreach to all the different communities in Los Angeles. We've had stories placed in the media. We had People magazine recently had one of our stories. So a lot of media outreach, digital ads, and then the targeted personal one-on-one outreach.
Okay. And I would love to know the stats, whether all of this is having an impact on reaching more tenants, low-income tenants. I have one more question. Oh, with regards to this follow-up question on this, do you collaborate with your court on putting some flyer or something as a UD case is open in the defendant's package?
So Stay Housed is just added to the court notice of UD that goes out to every tenant. The sheriff also will hand out a flyer to folks getting locked out. We've dealt with a lot of lockouts.
Mm-hmm. All right. And finally, you talked about paralegals who do a great job. They're supervised by attorneys that I right now don't remember. You were talking about your own agency or paralegals in general who are supervised by attorneys?
I'm just saying that certainly I understand the role of paralegals being very important, and they're important within all of our legal service programs as well. Mm-hmm. And I feel like that because they are supervised closely by an attorney, they can do a whole array of tasks that I wouldn't like to see paraprofessionals who are not supervised by an attorney take on.
And I'm just thinking about that, and a paralegal who's supervised by an attorney to do an answer or some sort of discovery instrument, and they've done that for 10 years, 5 years, and supervised. I wonder, and we've had this in other groups, committees come up, is that at some point the paralegal is really independently doing it. And because they've learned, they have, been supervised by an attorney. I'm just wondering, is it your belief, your opinion that a paraprofessional cannot be trained through all these trainings we're putting together to do some things independently?
Well, I mean, we follow the present rules, so attorneys look over any pleading, obviously that a paralegal does. Some education that they're providing. We just make sure that it's correct, and then also look at it with an eye towards representing at which point we need to step in to represent. Some more vulnerable tenants need representation far earlier than other tenants. So it's we just paralegals do a great job, but I think it's good that they have the attorney oversight.
Okay, thank you so much.
Julianne?
Thank you, Barbara, for your presentation and for the information. Earlier in your presentation, you talked about these sliding scale law firms, and you said something like you should figure out how to grow the capacity of these firms. I might have missed it, but how would you suggest this committee do that?
That is a really good question. I mean, I know there's an incubator project in LA with Southwestern Law School where new graduates join the program. Those are the folks that often want to start solo practice, but they have a whole training schedule. They come and they intern with some of the legal services to kind of really learn what they need to know. It kind of just occurred to me as I was talking, but it seems like we could think about ways of allowing firms to offer sliding scale. Even if they're doing some work non-sliding scale, like maybe there's some way to figure out how they could do some sliding scale work.
I just want to emphasize what Fariba said. Unlike notarios with whom you have had bad experiences, these paraprofessionals are going to be required to have what I consider to be a lot of education, clinical training in a particular narrow area that this committee and the Board of Trustees will identify. Also, they have to have considerable continuing education every year, which could help, even post-pandemic, with learning all of these various local, state, federal regulations and changes to those. It's my understanding, it's my impression that the Board of Trustees wanted us to create a program whereby these paraprofessionals could work not under the supervision of an attorney, and that we design licensing requirements that make sure they're competent to do that. So I'm concerned about your suggestion that we place these folks in, for example, sliding scale firms to work under the supervision of an attorney, or give them something to do which puts them in small claims court, which you don't have to be an attorney to work in. We're trying to figure out what paraprofessionals can do in a particular narrow field where they could help fill the justice gap. Do you have any suggestions on that other than security deposits?
Again, to me, the way to fill the justice gap in the UD context is through right to counsel. In other contexts, the small claims context, a variety of things are done in small claims, as we know, beyond housing, obviously. So, considering you can't take an attorney there, that seems like a good fit.
Thank you.
Amos?
Thank you. I'll try to be brief. Barbara, I know we've been taking a lot of time, but the LA Right to Counsel Coalition and State House LA is a very impressive and important movement. I think it might be helpful for you to talk a little bit about the multi-year nature of it, sort of how we got to this place, because again, I think the concern about undermining the political will to move forward on the right to counsel, to create the right to fund it, is a real concern. And there's been a lot of work over a lot of years to get where we are, where there currently is support at the county board of supervisors level, at the city council level, and more broadly with a lot. So do you mind just briefly talking about sort of how we got to where we are?
Sure. We came together about 3 years ago, or 3 years in the summer. A motion had been put forward in LA City Council to look at right to counsel soon after we started meeting. And we started meeting immediately with the mayor's office and a council office at the city. And we were devising this whole program. We really devised the multi-layer program along with the city of LA. And then soon we started also talking to the county of LA. So over the course of 2 years, as I said, we were designing a program that was going to be phased in by zip codes. We were going to start in maybe 3 courts. I think it was about 10 zip codes, and we were just going to expand from there. And then the pandemic hit. So that all changed, but what hasn't changed is our our will, and I think the political will is there too in LA to get to the full right to counsel. Our county partners have been extremely eager to see this work. We're always looking for new funding, for the next year, as is the city of LA and some other jurisdictions. As I said, actually, the city of Long Beach started with a $250,000 program, and they just agreed last week to put in another $900,000. City of Santa Monica just called me and asked for a contract because they want to start a right to counsel program. So, this, as you all know, I mean, the housing crisis existed long before the pandemic. The pandemic just kind of put it in more people's faces, to see, oh my gosh, what's going to happen when all these people get displaced. So I think we need, and especially in a place like LA, the homeless capital of the country, everyone has now recognized that, that people keep falling into homelessness, and the way they do that is through evictions, often, be those legal evictions or informal, as we call them, evictions. So this is, incredibly important as a way to stem the flow into homelessness, and to keep communities stable and safe, and obviously incredibly important for communities of color.
Thank you. And I'll also add that I think the Shriver Civil Counsel Act before that really led to it, because I think there's a lot of data that supports having an attorney in these cases makes a difference, and to level the playing field with an attorney, because there's usually an attorney on the other side, at least in some counties like Los Angeles. Thank you.
Yeah, absolutely.
A quick question, Barbara. The statewide effort for the right to counsel, I know you're part of that. Do you sense, is there some support behind that? I mean, is that something that you see happening in the future? And if so, when do you think that would happen?
I think so. Assemblyman Gabriel carried a bill last year that nothing really happened, but then he came back this year and really believes that this is the year to make it happen. Probably especially because there is the federal stimulus funding to kind of, start the pot, if you like, for the funding.
Okay. And if there is support, do you think that is something that could be implemented within a year, 2 years, 3 years? I know it's hard to get.
I mean, I'm hoping starting in 22.
Okay. Another question is, do you have a sense for how many landlords are representing themselves in LA County? And do you think that a paraprofessional would be helpful for your self-represented landlords?
That's certainly possible. That is a good question. I mean, anecdotally, I can't think that we see much more than like 10% of landlords that represent themselves. I think one of the public speakers, said that, that maybe we should look at areas where, the consequences could be so extreme. So, by having a paraprofessional represent a landlord or assist, a landlord, what's the worst case scenario? They lose and they have to start all over again. They don't lose their home. So yeah, I think that's a possibility.
Thank you. Linda, did you have a question?
Yes, I did. It sounded like the aspiration for LA was for full representation for people below 80% of AMI. And I see that that's the same thing in AB 1487. Do you think there's a need for representation? Are there tenants who are beyond that threshold, who don't qualify for free services, and there is a need that could be fulfilled there?
I mean, there certainly is, but because, like I said, of the existence of some of the sliding scale firms, they usually fill that need, as well as the higher income tenants. You know, in looking at who we've talked to through Stay Housed, and we were able, I'm sorry, under the county grant for limited service, we were actually able to go up to 80,000. So that 8,300 household figures could have gone up to 80% AMI, but we still see mostly far below that.
Any other questions? Well, thank you very much. You really provided a lot of great information that we can really sit and debate, and really helped a lot. So I appreciate your time.
I thank you for inviting me.
Thank you.
Thank you.
Okay, so getting back to kind of the one of the main questions for today is, you know, let's explore whether as unlawful detainers an area that we should include or not include in this paraprofessional program. Does anybody want to get us started? How about you, Amos?
Sure, I'm happy to get started. As you already know, as I've raised in prior meetings, I have serious concerns about including housing, and some of them, most of them were touched upon by Barbara and prior speakers. I think undermining the right to counsel movement is a big one. Now, again, to be fair, I have to disclose that I chair or co-chair with Justice Earl Johnson, the Right to Counsel Committee of the State of California Access to Justice Commission, and we've been following this for a long time. I can't say we take credit for any of it because it's really a grassroots effort in Los Angeles, as it was in San Francisco. But it's an important one, and there is a movement around the country, not just in California, on this issue, particularly in unlawful detainer cases. So I'm really concerned about that. I think my concern is particularly heightened if we don't have any kind of regulation of fees, fee caps or something else. I understand that's different maybe in family law, but in UD cases, there's often either a flat fee or a sliding scale fee that's available to get an attorney. And it was controversial 5 or 10 years ago to say anyone needed to pay at all for an attorney. They should get free representation, but people who, for whatever reason, there's not capacity or they don't qualify, they're better off with legal representation. There is a justice gap. People who represent themselves are going to lose. They need help. But I think the consensus is they need an attorney, and a low-cost attorney is the right alternative. And so the question is, if we're not putting any fee caps on, even in the cases where there's not a free attorney available, I'm afraid of the excessive fees issue. And so, you know, that's where I stand. Now, I do think, you know, LA is very lucky to have a lot of legal services providers and this movement for right to counsel. It's a big state that's not available throughout the state. So I do think there is a justice gap that, you know, we could try to address, but I think if we're going to do this, we need to really think through, you know, what the appropriate tasks are and not go overboard. It's not going to be trials and jury trials, in my opinion, and we can get down to the nitty gritty, but I think we have to include a discussion of fee caps as well.
Can I jump in for just a second, Judge Harper? I apologize. I missed the first 15 minutes, and so I may have missed this. Have you had a chance to update folks on your conversation with the Alameda County judge handling these matters?
No, I was going to include that in this discussion, but I can do that now if you'd like.
Well, I just think it would be helpful to have all the information before we start delving into people's views.
Sure. So last Monday, Linda and Lee and I met with Judge McKinney, who's from Alameda County, and he handles the unlawful detainer cases there. And he commented that first he hadn't heard of our program, so I think he was very interested in what we were talking about. But he was telling us that most of the tenants in Alameda County are represented by counsel, and that's I think through their legal aid services, not through a right to counsel program, but through legal aid services. And he didn't see a need for paraprofessionals for tenants in their county but he did think that there was a need for landlords. He did see some, he didn't really give us a percentage, but an amount of landlords who are representing themselves and at a disadvantage. And not to mean that someone should have advantage or not a disadvantage over the others, but he felt that a paraprofessional really would be helpful for landlords to have that availability, which is in line with what I deal with of my county, where we see a lot of self-represented landlords and tenants because neither of them can afford attorneys. They're basically landlords who are living off of that rent. When that person doesn't pay, they don't have money to go hire an attorney. And so they represent themselves. I think you see some of that in some of the smaller counties. And so he felt that the paraprofessional program would be helpful to help landlords. He was very interested as well, was very upfront about wanting to take data because he understood they may be a pilot program and that he would be up for doing the data collection and really trying to see how the programs are working. Linda, did I miss anything or Leah?
No, I think that.
Yeah, and I'll just add, having been in Alameda County, the legal defense, the eviction defense folks are fantastic. One of the attorneys is actually now a judge, an appointed judge with the Alameda County Superior Court, who came out of that program. I don't know if you had a chance to talk with him though, because my concern, and it may be that our program is too late for it, is I'm not surprised they're covering everyone right now. When I was there, they were not able to cover all of the tenants who needed help. And that's because we did not have moratoriums in place as we currently do. And so knowing the program, I cannot imagine.
Yeah. He did mention that during COVID times, obviously the numbers are down. So he did mention, obviously there is going to be a big push, I think, our big influx of cases here coming up.
Yeah.
Ira, did you have some information?
I was going to state my view on. I am, I've been really in favor of paraprofessionals in housing, but I am very concerned not to do something that'll interfere with the right to counsel movement. And what it occurs to me now that I don't think we can. I think we ought to find out from people in the right to counsel movement what jurisdictions we ought to exclude. There may be some who are on the verge or likely to have a right to counsel law in their jurisdiction. Some who, I'm guessing that San Bernardino County, a very big county, it's not likely that'll happen there. I would guess that it's nearly impossible it's going to happen in Kern County or Bakersfield, which are it's a fairly big county and very big city. I think we should consult with them on this.
Thanks, Sarah. Fariba?
Thank you. I also don't want this program to in some way compete or slow down or derail the right to counsel movement and programs. I just don't see it. I just don't see where there's even a concern. It's not like this program is gonna shepherd all these tenants that would otherwise be represented by a right to counsel attorney towards paraprofessional. And I just don't see why we have to eliminate the choice completely, to take away the choice from a tenant. Even though they're low income, they should have the choice. If they can get together some money and hire a paraprofessional, they should be able to do so. Amos and I are working really hard with bar staff to come up with informed consent, and perhaps we have to work on really putting that information in there about the option to a right to counsel program in their county, however that informed consent is going to look like. I am just not comfortable with eliminating an option altogether in favor of a right to counsel program. I don't see a competition. I think that, as Barbara said, the way they do outreach and they put information out there, if that's done really well, then tenants, hopefully for the most part, not everyone, but for the most part, will have information about their options and will select one that's best for them. We should not be making the choice for them. And yes, being represented by an attorney is it's the best option. Well, there are bad attorneys out there too, but it's the Cadillac standard, right? And that's, the ultimate goal. But frankly, again, that's not possible. No matter how many of these legal aid programs you have, it's just not going to be enough money to have every low-income litigant that needs an attorney could get one. So we need to have these other options for them available. A really well-regulated program is going to do a lot. All the good people on all these various committees are coming up with licensing, education, regulation, all these standards to really regulate the bad actors out there that are, going crazy. And by the way, if we don't regulate the UD portion, these bad actors are still going to be out there. And as the notarios that Barbara was speaking of, they're still going to be out there and they're not regulated. So they're going to, do the bad work they're doing. I think filling the gap with options is the best way to go. Thank you.
Thank you, Fariba. Julianne?
Thank you. I agree with Fariba very much. I would actually like this group to look at the list that Fariba and Ira prepared, the list of tasks in a UD proceeding, because I found that to be very helpful. We could look at it and ask ourselves, what risk are we really posing to either the right to counsel movement and or the clients who are given a choice as to who to hire? And I agree that to me, it's completely expectable that large counties like Los Angeles and San Francisco are going to, spearhead a right to counsel movement and somehow find the funding for it. But Judge Harper, I doubt your county will ever have a right to counsel movement. Yeah.
I agree.
Yeah. So all I'm saying is that there's a lot of people in a lot of counties who would be in need of this. And I am also uncomfortable with depriving them of that choice.
Thank you. And I agree with both you and Fariba. I don't see it where it's a competition. I mean, if people can't afford an attorney and they can get an attorney from the right to counsel movement, then that's where they're going to go. But to give them at least an option, I don't think that's going to interfere with their ability to have that counsel that the state or that county or that city is going to provide them. So I don't see it as being a competition. I believe it's a service that could benefit both. Amos?
Yeah, so I do want to follow up on that competition point, because I think that is part of the concern, but definitely not the whole concern. So competition, the concern is that somebody may end up paying for a paraprofessional who could get free legal services. That's the competition. And so I think that, Fariba, is what you're describing, that there might be some disclosures or referrals or informed consent where we could try to regulate for that, but that is a concern. But I think the much larger concern for me, and I think what Barbara was expressing, is that it is possible and maybe even likely that rolling out a paraprofessional program in the housing context undermines the ability to, and the political will, to create and fund a right to counsel. Because if, it's not easy to get a political body like a county board of supervisors or a city to vote in favor of spending quite a lot of money and establishing a new right and funding it, finding the money for it now, but also planning to find it and budget for it going forward. And any excuse like, why can't they just go to a paraprofessional program? The state bar is setting up a paraprofessional program, really undermines the multi-year effort to follow New York. And, I think it's a nationwide movement, but certainly what's happening in Los Angeles that is going forward. And so the risk is we undermine that. Now, there might be some things we can do. I mean, I think this working group, this committee, this working group, the State Bar Board of Trustees, maybe even the California Supreme Court might be able to, make statements supporting the right to counsel efforts and making clear this is not intended to undermine it. But I don't think that eliminates the concern that it really might be undermining this movement we have that is directly addressing, and there's data to support that it really is addressing in the best way to address the justice gap in UD cases.
Thanks, James. Leah?
Okay. I think what I want to say is I fear that not including housing would appear quite tone deaf, given the realities that we know are out there, irrespective of geographically specific right to counsel initiatives. I do think that the pending legislation, I think it's AB 1497, which would effectuate a statewide approach, is something quite different than what I currently understand to be a very, city or county-based effort. I personally don't think that this statewide body should necessarily make decisions based on initiatives that are based on what is going on in the tens of thousands of cities in this state or the 58 counties, because I don't think we're going to get a statewide approach that way. And I don't think you all should make your decisions based on what's going on in any particular cities or counties. But there is this bill that's pending that would fund representation statewide for tenants up to 80% of AMI. And I'm wondering if there's a way to think about your work in light of whether or not that bill passes. And we will know that, over the course of the summer and the fall. We'll certainly have some better sense of the likelihood of that bill passing. So that's one thing I wanted to say. And the second is that there are tenants over 80% of AMI who are not going to qualify, even if that bill is funded. And I agree that those folks should have a choice. So those are my comments.
And Leah, looking at the bill, and maybe if I'm wrong, I just kind of scanned it. It looked to me that it's offering grants that can be applied for. That is it going to be an unfunded? It's not going to be a statewide mandate. It's going to allow certain jurisdictions to apply for funds if they choose.
That's right. And it would be distributed by the state bar, but not on the current funding formula that's used to distribute, like the IOLTA money. Nonprofits can apply, government agencies can apply. And I think there's a 20% set aside for rural parts of the state. But you're absolutely right. It's based on applications. And in fact, even that rural set aside, the language says, if you don't get enough qualified applicants, you don't need to spend it, in rural areas.
So even if that passes, we're still going to have a portion of our state that is not going to be represented through the right to counsel.
Nobody may apply. That's true.
Yeah. Okay. Thank you. Ira?
Yeah. I want to pick up on what Amos said. I've never thought of the conflict between right to counsel and paraprofessionals as a matter of will somebody choose a paraprofessional as rather than a lawyer or vice versa. That's not to say that I don't mean that that's an invalid concern, but what I've always thought of ever since I heard people talking about this is months ago in the LA housing arena is the political aspect. The lobby, the landlord's lobby, the California Apartment Association, I suppose there's others, is tremendously powerful. So you all know about the Ellis Act. That word might not mean anything, but it's the law that passed about 20 years ago or something like that, that very seriously rolled back a lot of rent control protections. In fact, a lot of people say there is no more rent control, it's rent stabilization because of the Ellis Act. And so you give them an argument saying, oh, we've got, now we got this paraprofessional program endorsed by the state bar, created by the state bar, and then blah, blah, blah. And so we don't need this. And people will buy that. You'll see that on television probably. But that said, we could have the paraprofessionals represent people who are above 80% AMI, and in counties, and only the counties where there's no realistic chance of having right to counsel.
Anybody else? Well, I'm sensing, I mean, generally speaking, I think taking into a lot of the considerations that Amos brings up, and I think we're going to have to delve into those. I think the fee caps is obviously a huge issue. We're going to have to address at some point, I think, the bond requirements, but I think generally speaking, I think moving forward, I think there is a need for a paraprofessional in our state in these types of cases, and we may be able to limit those down. I think the subsidy issue, subsidized housing and the rent control, those are obviously areas we're going to need to talk about, whether they can maybe be excluded as part of the paraprofessional program because they are so complicated and maybe need some specialized education, specialized training for that. So I think there's a way to pare this down, but I think generally speaking, the consensus to move forward to include this, I think obviously it's something we can bring up again if we get to a point. But at this point, I think let's move forward and then see if we can tackle some of these other issues as we move along. Go ahead, Amos.
Can I just recommend, since we just did hear all that information, that we do, I don't know if we need to vote on it now or we just make a note of it and remember it, that I think whatever we do, we really need a strong statement by this committee and maybe the full working group about the desire not to undermine and that we support the right to counsel movement. And the stronger we can get it, obviously, the better. So I don't want to try to come up with something on the fly, but I think, I think the state bar may unintentionally be undermining the right to counsel efforts if we do move forward. And I would like to do what we can to minimize that.
Absolutely. I think anything we do to move forward is to try to not undermine the right to counsel, because I think it's obviously a very important movement. And I think that it has a lot of great good that's going to do for our state. And I agree with you. We don't want to undermine that in any way. Did everybody get a chance to look at the task, the unlawfully detained task that Fariba and I put together, and also the title clearing tasks? First of all, thank you guys. I think those were terrific tasks put down. So it really, I thought, did a good job of summarizing what we were doing. And so I guess I was going to take up the title clearing task first. And I know we put on the agenda is that something we think that should be included? And I thought, Ira, your synopsis, I thought just really did a good job and convinced me that this is something that not unlawful standard, but the title clearing is something a paraprofessional could take on and help with quite a bit. Can you maybe give us a sense for what your thought was behind the task list?
Yeah, good. Okay. Well, let's see. I had the thought in the beginning that it was kind of just a matter of common sense thinking it through what paraprofessionals would do, because there's liens, you want to try and get rid of them, you need to, anyway. Then I went online and I saw that there are law firms and non-law firms advertising for clearing of liens, clearing of title, without the, well, with and without an action for a lawsuit for a quiet title or anything else. So I went, they didn't have lists of tasks, but they did give a general idea of what could be done. The forms for a clearance are, I said they're available online. There's some tasks here that people would argue are, it occurred to me anyway, that they're a lot more complicated than others, but some that appear to be that aren't, like statute limitations. On a lot of liens, it's really simple. You have to bring suit within a certain number of months or years after you record the lien or file the lien, depending on what kind of lien it is. Others, though, for instance, a judgment lien, that's simple too. I mean, it expires, I think the lien expires when the judgment expires, which is a 10-year period. And so that's simple to do. There may be liens where you've got to figure out if they're not judgment liens, you got to figure out if the underlying claim is expired, and that's a little more complicated. But anyway, that's all I can think of saying right now.
Okay, well, I appreciate it. That was very helpful information. Does anybody have any problems of including the title clearing for a paraprofessional to handle? Amos?
So I think we should avoid the title clearing name because it is confusing, and I'm
Sure, I
not
agree.
sure that that's what this is. It's lien clearing, which is different.
Yeah,
I
right.
think we want to, and I think Ira has endorsed this, that we want to exclude like title fraud type issues that would require, litigation and reconveyances of a void or require some showing of fraud or something like that. And we separately, I think, excluded probate type issues. So I think this has nothing to do with the title necessarily. And maybe even we want to exclude title transfer type issues or documents where you risk losing the house. So this looks like it's much more narrowly focused on lien clearing, which is frankly consistent, I think, with what we're separately doing on the consumer debt or looking at. We haven't decided yet, but this is more of a consumer debt. If there's like a mechanics lien or judgment lien, which may have nothing to do with housing, it's just a lien on the house.
Okay.
I think we should make that clear.
Yeah, absolutely. I think that's a good suggestion, is making a lien clearing and not title clearing. Julianne?
Thank you. Ira, in your presentation, you said something about you went online and you found some law firms and some non-law firms offering this lien clearing service. What kind of non-law firms are doing this? And is that the unauthorized practice of law, or do you not need to be a lawyer to do this already?
I'm not sure you need to be a lawyer to do some of this stuff, but what I found was we call it LegalZoom and another company like that, or maybe two or three. And well, LegalZoom now does have lawyers that you can get some consultation from.
Right.
That's the non-lawyer stuff I found. It's an easy Google search. And the more effective one was lien clearing or lien elimination or something like that, as opposed to title. Although you get it both ways. You get these hits on Google.
Amos?
And Ira, can I also assume that assuming the forms or negotiation is not successful, that you are not expressing support for a follow-up lawsuit that might be required? Is that right? This is just the non-litigation aspect of lien clearing. Is that right?
That is correct. I tried to make it explicit in the last paragraph, number 5.
And I'm pretty sure we even said that in our initial document dated June 30th of 2020.
Yeah, I think we did.
Anybody else want to be heard on this? So we're in agreement that this would be the lien clearing as described here by Ira's document, that would be it should be included on the housing paraprofessional person. Okay, I don't see anybody objecting to it. And at some point, we'll talk about the bond requirements. I know Amos, you're involved in the regulation and the bond issues. I don't know if it's something we need to talk about now, but I know at the meeting on Friday, there was discussion about each working group can then discuss if we want to have a different type of bond requirement. What are your thoughts on that?
Yeah, and Fariba's on that regulation subcommittee with me. Yeah, I mean, I hope we don't drive a truck through that provision, which was really like for collateral criminal expungements.
Mm.
I think Fariba and I already have considered housing and family law and consumer debt, the ones we're on, and felt very strongly that the $100,000 bond was required. But I think technically, given the resolution that was passed, I think it is up to each of the subcommittees to have that discussion with a strong default for the $100,000 and really needing to come up with compelling reasons to diverge from that.
Okay, and Fariba, you agree with that?
I do. I think that we are looking at the same vulnerable population or consumers that would be using immigration consultants, and we sort of went off of that. Having Amos and I talked, and I understand the concern of the working group about not having the same high bond amount, for example, for expungement. And I would agree that each committee decide on their own, but there absolutely has to be a bond and higher for things like housing because of the ramifications of doing really bad work. Same thing for family law.
Okay. Ira?
Does anybody know whether real estate brokers, when they're handling a sale, or it's actually would be more, well, anyway, they're handling a sale or purchase, and a lien comes up that interferes with the closing. Do they help the clients clear the lien? Anybody know?
My understanding is that that's, you know, at the point of the sale, that's one of the things that's handled in escrow. So that the title search will turn up a lien, and then that lien is cleared through the escrow process. I don't know if they do anything to help sort of challenge the lien. I don't think the title companies get involved in challenging the lien.
Yeah,
Well,
usually they need to be paid or negotiated quickly.
Yeah, I don't think they do. I think that I agree. I think the title search tells you what, if there's something there, but I think it's on the client to then go clear that title.
Yeah. I had personal experience with that, and I remember that there was facilitation of this thing came up, and we had no idea, and then just getting us in touch, but they didn't take part in any kind of negotiations or anything like that. That was up to us. I think that's what they do, is just facilitate.
Here's a here's another proposal we should add, that the legislature pass a law that a real estate broker has got to help their client clear title if it's getting in the way of the escrow. I mean, what else are they making their money for, you know?
They can hire a paraprofessional.
Right. They could
Do
do
you
it
have any problem with the $100,000 bond for housing? Or do you have any problem with the
Do I have
$100,000?
it? Again, it's for, I don't know if everybody was in that discussion, heard that discussion about the bond. It can be up to 3%. And well, the estimate was 1 to 3%, and 3% if you have problems with your credit, you, the paraprofessional, and lower income people do. And 3% of $100,000 is a lot. And I favor having the first year of the paraprofessional's licensure be a $25,000 bond, and thereafter the $100,000. And one thing to keep in mind on that is that it's kind of like malpractice insurance. It's unlikely that well, not unlikely, it's way less likely that a claim will ripen and then take the money from the bond in the first year of the paraprofessional's practice than in later years. Although it's possible.
That's your belief across the board. That's just not housing. That's for everybody.
Yeah, that's my belief, right.
Julianne?
I have no strong opinion on this, but I don't want the bond to be an impediment to a barrier to entry.
Well, it will be, I think.
I think that it will be.
$3,000. You know?
Yeah.
Okay. Well, I think the 100,000, I listened to the presentation and I thought it was well presented and really justified the need for it. And I understand Ira's position is that you're just starting. What are the chances that you're going to have to pay up to that $100,000? I get that part of it, but I thought Amos and Fariba, the presentation really justified the need. So I was in support of that. And I think what Amos, you're saying, the default was really the 100,000. So I think at this point, we'll just go with that, and then we can bring it up for other discussion later if need be.
Sounds great. Thank you.
Time is it? We're at 2:30 right now. I appreciated again, the list that Fariba and Ira put together regarding the unlawful detainer task. You want to start kind of going through that and see if we can agree on what to include for tasks for paraprofessional? And perhaps either Fariba or Ira, one of you can kind of take us through the thought process for this.
I'm happy to, Ira, did you want to go ahead, or I'm happy to yield?
No, go ahead.
Okay, so I just want to acknowledge the assistance of my lead staff attorney, Joanna Van Dat, with this task list. It wasn't all my work. So we started basically looking at the different stages of life of a UD, well, pre-filing and post-filing, and then
excuse me, I think I have the wrong list up.
Yeah.
I'm going to replace it. I didn't put up the right list.
Oh, that's not the final one. You're right.
Right. Sorry about that.
There was some
Go ahead.
disagreement between Fariba and me about what should be included, excluded, a few of the tasks.
And we really left the trial portion to you, Ira, because my staff really doesn't get involved at all. We're really just involved in the pre-filing and then the answer part defaults, and then post-trial with set-asides and things like that. So I think you expanded on that area as well, and we appreciate it.
Okay, I think I have the correct list. I apologize.
And do you mind emailing that around as well?
I think I sent it out
Oh,
on
the
Friday.
email was the right list,
The email
the
was
latest, yeah.
yeah. Oh, here we go.
I wonder, do you see Joanna as a participant, Linda? I know she's been monitoring, but she's also at the office helping people, but.
Let me see. Yes, she is. You want me to move her into this?
Would you please? I don't know if she's sitting at her desk right now. Oh, she's there. She's there. Okay. I'm just going to ask her to present the list. Are you here now, Joanna?
Yes, can you hear me?
Yes. Hi. Go ahead. This is Joanna Van Dat. She's the lead staff attorney for my office, principally responsible for all of our non-family law tasks, along with family law, but she's does a lot of non-family law tasks. Okay, so go ahead.
So I got a chance to look over what Ira put in, and I believe that your recommendations, Ira, were that most things be included. I think where we differed was the things that we don't prepare in our office or we thought were more complex. We had either put question marks by or excluded. So the way it was broken up was pre-filing with the landlord. We agreed that the notices can be included, the summons and complaint, and the attachments could be included. And then for the tenant, I appreciate that you broke it out into all these different tasks. We generally don't, so we'll help people with the answer, I should say, but in terms of getting documentation for what it is that they want to attach, we give them information about it, but we wouldn't gather that for them. Does that make sense? So generally, sometimes they bring in a lease, most of the time they don't. It's usually attached to the complaint, and we'll go over it with them to make sure that that's indeed the lease that they signed. Let me think. So yes, with regards to our affirmative defenses. I remember in the original list, we had put a question mark because a lot of the times we'll go over with the customers what they mean, but we don't necessarily, guide them one way or another. It's that fine line of not providing legal advice to them. So for instance, if they believe it's discrimination, we'll ask them to write the declaration about that, or retaliation. Let's see, what else? Yes, we haven't negotiated with the landlords.
So I'm going to interrupt for just a moment. So Ira, you added this pre-filing stage tenant all included list. And I was just wondering, so we consider this legal advice. And as Joanna explained, we sort of give them the information, but don't make the decision for them. And also don't write the declaration for them or anything like that. But you felt that all of this, a paraprofessional should be trained enough to question, interview the client and come up with and word theorem sort of, and to try to do the best they can in the affirmative defense portion of the answer, correct?
Yes, I wouldn't have said so. I wouldn't have said that paraprofessionals could do all of this stuff. For instance, determining, going through the COVID-19 laws. I don't know if I even mentioned that, but some of the rent stabilization laws. I wouldn't have said it until the last few months, when in these what she call them, workshops that Barb mentioned a little while ago. That same meeting. Anyway, workshops that I've attended, and so have many non-lawyer members of the Los Angeles Tenants Union. And these people are pretty good at knowing some pretty complicated stuff about the newly complicated law of landlord-tenant. So yeah, I think a good paraprofessional could do this. I mean, the people I'm talking about haven't really been trained other than a few seminars, but they're smart and they've read the stuff. They know it.
Okay, very good. Okay, Joanna, sorry.
No, thank you. That is helpful. I think we've also come to it from the perspective of, we see how if something's poorly done, how much work it takes to undo it in different areas, of course. And I think different people have already expressed those opinions, so I can appreciate that. And so, yes, if you feel that, given proper training and the information that they need, they can do this, then I think, sure, that can be included. And then, yes, definitely post-filing, the answers. So the affirmative defenses, that's where I had kind of explained, where we will explain what they are, but don't necessarily tell them if they apply in their particular situation. But if they believe they do, then they'll write the declaration. We do help. So in our office, the way we did the request to enter default for the landlord is that we'll help them with it and then do the judgment in two parts. We'll generally do the judgment for right of possession first. And then when it comes down to the monetary, we'll do that at a later stage, or they could take that to trial. A lot of the times, the landlords, the self-represented landlords that we're talking about, are either people that are subletting another room, right? So they may not be the owners of the home. They're not these like large landlords or anything like that. So for them, a lot of times, this was pre-COVID, they really didn't think that they were going to be able to collect the rents anyway. So what was most important for them was to get possession of the property. So that's when we've seen, we assist them with it. Let me see. And because we don't do any trial prep at all, we had put question marks, but I would trust Ira's judgment in with regards to what can be included. So you had question marks about the jury instruction and the special verdict forms. I can't speak to that at all, Ira. So did you want to talk about those?
Yeah, those could be pretty hard to do for a lawyer even. So I'm just not sure whether paraprofessionals ought to be doing that on their own.
Okay.
And if they're not, then they can't do jury trials.
Right, and let me just jump in on that, just to echo what Ira was just saying. Those are hard. There are so many different ordinances in different cities and counties and places, and we do not have good standard, unlike some other areas of law where you can just pull up the jury instructions and you have a default set to go. You don't with this. This is something that attorneys struggle with and courts struggle with. And so I'm leery of any kind of jury trial in this arena. I don't know what Judge Harper thinks.
Yeah, I agree. I mean, well, obviously, I think the working group as a whole, we're going to decide whether the paraprofessionals can even go to court or not. So that will help dictate. But I agree. I think obviously if the working group says they can't go to court, then I think obviously this isn't an issue for a paraprofessional.
Yeah, I think it's hard to divvy up, either you're doing trials or you're not.
Yeah.
So you can't say, for example, not that you can't, I don't think it makes logical sense to say that they could prepare an opening statement for a jury trial, but not prepare jury instructions. Yeah. Either you're doing the trials or you're not.
So then, Your Honor, would you cut it off at the preparation for trial with just the discovery portion of it and leave everything else to be excluded?
Probably, and I also don't want to necessarily exclude. I mean, often these are jury trials, but when I was on the Superior Court, sometimes they would agree and they wanted a bench trial, which might, one might view that differently or not, but it's something to think about.
In our jurisdiction, most are court trials. They're not jury trials for unlawful detained.
I got to say though that if we, I think it'd be a problem for us to say, okay, paraprofessionals could do bench trials, but not jury trials.
Right.
The reason is that it would give the paraprofessionals a big incentive to waive jury, and that's exactly what a tenant shouldn't do.
Yeah.
Yep, that's a very good point.
Yeah.
It's I've never tried a jury trial. I'm not a litigator, but it's a whole different skill set, I would say, to do a jury trial than a bench trial. It's just a matter. What? Sorry.
It's a lot harder.
Right. So is it just a matter of saying no trials or training them to do jury trials?
Mm.
And
I don't. I mean,
actually, no. Sorry, we're talking about in-court representation. Sorry. So I don't want to start.
Right.
Are we doing that today?
Well, we're doing it with the whole group, so.
Okay.
Yeah, I guess if the whole group agrees that they can have in-court representation, then we need to come back and discuss this, whether it's appropriate for a paraprofessional. Now, if they're going to allow paraprofessionals to sit there with the client in court, then, but I think we're going to have to readdress this after the working group as a whole decides it.
Okay, I lost myself for a second. Sorry.
Myra had his hand up.
There is though, there are hearings before the trial where a paraprofessional, I think, could do a good job. Sometimes there are motions, and there's these settlement hearings.
Yeah, I agree with you. I think the settlement, I think that's exactly where they would.
Yeah, I think so too. I think the settlement stage is where it can be extremely useful. Yeah. But it's an interesting point that Ira raises about, you don't want to incentivize people to waive jury trials, of course. And then it's interesting to me to hear that, like where Judge Harper is, most of these are already bench trials. I mean, we really see a lot of differences county to county.
And then I know they were saying in San Francisco, they asked for jury trials in all their cases because it helps push the case along. So
yeah, so do we here in LA.
Yeah, we don't have enough jurors to do jury trials on unlawful detainers, so it's not an issue here. I had a question, Ira. The part up in the paragraph up above for the determining whether it's rent control or the subsidized. Are you rent stabilization ordinance? Are you saying that they would be able to handle those types of situations, or do we need to discuss whether that should be excluded from a paraprofessional, where they then need to go get legal aid or an attorney? Because I know that we had some public comment about the complexities of rent control or federal subsidies and concern about a paraprofessional handling those.
No, I don't think it's hard to determine whether rent stabilization ordinance applies. I mean, you gotta be careful enough to look at the map or whatever other and figure out where the the housing unit is. And sometimes that's a little complicated. In LA County it is, but once you figure that out, you know what ordinance applies.
Okay.
Or it could be multiple ones, could be two.
And then would your thought then be that the paraprofessional could handle that case, even if it's a fairly subsidized housing or rent control?
Could handle it before there's an unlawful detainer. Yes, I think so. Yeah.
Okay. But then once an unlawful detainer is filed, then they should be farmed out to an attorney.
Well, not necessarily. I remember we're talking about trial and things that happened before the trial.
Yes.
So some of those things paraprofessional could handle. But somebody made a point in one of our meetings months ago that to have a paraprofessional do the settlement hearing, if there's could be a problem for the tenant, because if there's not the threat of actually going to trial, then the negotiation is much weaker. But the paraprofessional could handle that hearing and let it be known that there's a lawyer ready to become of record, or maybe there already is a lawyer of record, just the paraprofessional doesn't work for the lawyer or under the lawyer.
Amos? You're on mute.
I wanted to follow up on that exact point Ira just made, and then I had a separate question. So I do think the dynamics of paraprofessional versus an attorney makes a potentially very large difference in negotiation, especially in jurisdictions where jury trials are commonly demanded, and if paraprofessionals are not going to be able to do either in-court representation, or even if they are, not do jury trials. So I do think that's something we need to seriously consider. I also think we should hear, we've heard from Barbara today and Barbara from LAFLA today, and Trinidad from the Neighborhood Legal Services last meeting. I would love to get their feedback on the task list in terms of what should be included or excluded and why. But my question for you, Ira, and Fariba, for this list, was there anything that you, besides the trial, was there anything that you looked at that thought should be excluded, that you thought would not be appropriate for a paraprofessional besides trial?
You want to go down, Linda? Do we have a second page there? So we have some more question marks. Did we discuss all the question marks already?
No.
Okay, so I suppose, Amos, we should just continue with discussing the list and then get to the excluded. Not a lot, but there are some question marks.
So I'll just note that Barbara also mentioned that legal services currently does a lot of pre-filing things or limited scope services. I think in my limited experience with UD cases, a lot of times a tenant's best defense is an offense, so to file habitability complaints with the city and things like that. And so I think we might want an even broader pre-trial list of things that could happen. And we also talked about, security deposit issues and other things that might be pre. I'm concerned about the motions and the discovery, and I think I'd like to hear from legal services on that. But I do think there's probably a number of tasks that aren't on this list that could be in the non-litigation context.
Yeah, I agree.
Yeah. So I suggest that we continue and then do ask, legal services agencies to review this and add their comments.
Okay. I got
Okay. Yeah. Okay. So where did we stop?
I think right above where this was, I think so.
Yeah. So, oh, that's right. Jury instructions. Okay. So I think we can move to 7. Yeah, Joanna?
Yes.
Okay.
So for most of these, I thought that we weren't sure, and that's why the question marks are there.
But I think that we wanted, if we want to comment on the settlement negotiation, I think we already talked a little bit about that.
Mhm.
We see a lot of abuses go on in the hallways.
Right.
And we think that a paraprofessional could really help. And I think we just commented on that. So are there any, first up, do you have any comments? I think we did make some comments. Is there anyone who wants to oppose including ability to participate in settlement negotiations?
I'm not opposing it. I will say though, when Ira mentioned, that it might not make sense to do bench trials, but not jury trials, because it causes an incentive to not request the jury. I think you have perhaps a lesser but related issue here. I do think that they should be allowed to participate in settlements, but of course, if you can't then take it to trial, there's some, potential there of that impacting what advice is being given.
I think another problem we have in here is the timeline, because an answer, 5 days to find an answer. Once an answer is filed, trial has to be set within 20 days. Often the landlord and the tenant, the first time they meet is at trial. There's no settlement conference.
That's what I was thinking about, is when I used to be the head of the civil division in Alameda County. And so I'd be divvying up the unlawful detainer trials. And, there were a limited number of people who would be available on any particular day to do them, and we would stack them, right? And so the judge would have like 3 or 4 set for the same day, understanding that it was going to be real time that day that they would try to be negotiating resolutions, and whatever was left standing, we had a jury ready to go.
Right. So I think that I just can't imagine a situation where, like you said, trial 20th day, the one and only day that they meet, they do settlement negotiations outside. If it's not successful, then the tenant is going there by themselves, because we're not,
Right.
we haven't decided on in-court representation, but let's say there's a decision that there's no in-court representation. Then there's no time to get an attorney in there.
It's a serious problem, because I imagine it's the same in most counties, that it's largely getting negotiated as you're sitting there waiting to decide whether to pull in the jury panel or in the counties where it's more the judges getting ready to go. And of course,
that means we have
part of the negotiating strength on either side of any negotiation is the willingness and ability to say, let's go.
Yeah.
Well, I think we're going to have to come back to these after we just decide what level can a paraprofessional go to court, or can they be in court? Can they be sitting next to them, or can they actually talk? Can they answer questions, or can they actually, that's going to.
I agree. I think we should have TBD for settlement negotiation as well.
I think the default judgment by court, that's actually something that paraprofessional can do. 7A, I think is okay.
Yeah.
I agree.
On settlement negotiations, it just occurred to me that if the tenant's got a paraprofessional, they could get in touch with the landlord's lawyer before trial and try and work a settlement. Now, a lot of landlord lawyers say, well, I don't know anything about this case till I walk into trial that day, but it's possible.
I don't know about other counties, but in our county, there's like 2 attorneys that represent 90% of the landlords, and they will not answer any tenant's call. They don't care. I'll see you in court, because they know, they want to put the tenant in that position. So, that's a great idea. I just don't know if it's realistic for every county.
On the judgment writ of execution, it says excluded. Is there a reason that was excluded? I think that should be included.
Yeah, that should be included, I think.
Yeah,
I think it is included.
Okay, I think it just got, I think that.
That might have been a transcription error on my part when I combined the 2 lists.
And then I thought all the post-trial stuff included was appropriate.
The only reservation I think we had about that were just the motions to set aside the judgment and to recall the writ and the proposed answer. But I see if the paraprofessional has enough training, right, to figure those out, then it should be okay. It's just like the one packet in our office, we're really like careful about, handing it out and going through it with people to just really make sure, because we tell them, you got one shot at this.
I would hope they'd have the training to do that. That should be part of there. Okay,
Okay, that's it.
that's a great list. Thank you guys for doing that. Really, it's helpful. And I
Thank you,
guess
John.
we'll have to
Sure.
come back to this. I agree that we should get some legal aid services and maybe the right to counsel people to look at it, like Amos suggested, to get some input of whether some things like we could add or subtract. And then we'll know a lot more after Friday, hopefully, about whether paraprofessionals can even go to court. And if so, then we can come back and readdress these issues.
And I think it might be important, Judge Harper, and maybe, leave it to you on Friday to, when we're having the conversation about in-court representation, to think about the ramifications, but not only the in-court, but for example, with these cases, the impact on the ability to try to negotiate resolutions.
Oh,
Yeah, really great point.
And
We
I'm
have
just-
another meeting scheduled for April 5th, so we can revisit this. It'll be after the discussion about in-court representation.
I'm
Go
just wondering, the in-court representation issue, that's also could be decided per committee, right? It doesn't have to be an across the board.
Right,
No
I think what
input.
we're going to wind up with is a default position. And then if any particular subcommittee wishes to do it differently, there needs to be a strong justification for doing something other than the default. Because we need to give everyone a place to start. I don't want it to be a free-for-all every time starting from zero. So we should have an overall sense for what is the committee's position, but I would not want to do it. I would want to leave any particular subcommittee an ability to recommend otherwise and explain why.
All right. Well, it's 2:58. So Lynn, I guess my question is, how do we get this list out to the different agencies? Are you able to do that so they can review it and give us some input?
Sure, and maybe I can consult with a couple of people to get ideas about where to send it.
Okay, great.
I want to be sure we don't send it to some organization that's just going to say we
They're
should
gonna
exclude
gut it.
everything.
Yeah,
That's a
exactly.
concern I have.
Yeah.
So, okay.
All right.
Thank
Anything else anybody wants to add before we finish up? All right, thank you. I think we covered a lot of stuff today and
Yeah, great meeting, thank you.
yeah, thank you all.
Thank you.
Bye.
Bye.
See ya.